AC 482, the Queen v. Bura, 5 IA 178, 1878, 3 AC 89904, 905, and Mohammed Samsuddin Karyapalur VSS, Vijay in Luzal, 1968. AC 7 was 17, 743, RCF CRRCD, 10, the Constitution. 29th Amendment Act is I. Ecta J to protect the impugned acts if they abrogate or take away funda. Nello writes, the argument that Article 31B is limited by what is contained in Article 31A cannot be accepted. P. 213, State of Bihar vs. Maharaja Diraja Sirkameshwar Singh, Lanembi Satan 52. STR Lapindiran Pampulsinlan, 9-1-14-15, Sibnath Baneri's case, 1945. FCR 19, Visweshwar Rao v. State of Madhya Pradesh, 1952, SCR 1020-1037, and NBG Bhoiviri. Assistant Collector Thana, 1965. ISCR 636-64111, referred to. Article 368 does not enable the Parliament TN abrogate or take away fundamental rights. If this is so, it does not enable Parliament TN do this by any means, including the device of Article 31B and the 9th Schedule. This device of Article 31B and the 9th Schedule is bad insofar it protects statutes even if they take away fundamental rights. Therefore, it is necessary to declare that the Constitution, 29th Amendment, Act, 1971, is inceffective. TN protect the impugned acts if they take away fundamental rights. J. Broadly speaking, constitutional amendments high carto made in art, Clause 19 and Article 15 and the agrarian laws enacted by Vanuo S12Ts, furnish illustration, FF reasonable abridgment of fundamental rights in the public interest, Kesavananda v. Kalale, Sheet, J. 13 Proprietary Articles Trade, Association v. Attorney General for Canada, 1931, AC 310, 3con17, and Attorney General for Australia v. Fods. The Queen and the Boilermakers Society of Australia, 1957, AC 288323, referred to. The fact that it takes years before the validity of an enactment is finally determined is not a good reason to deprive PC nons of their fundamental rights. There are other ways available to the government to expedite in the decision. It may, for example, propose ordinary legislation to enable parties to approach the Supreme Court for transfer of such cases to this court for determination of substantial questions of interpretation of the Constitution. She. Adam Grover, J.I. The Constitution. 24th and 29th Amendments are valid. Section 3 of the 25th Amendment must be declared unconstitutional and invalid. The decision in Golak Nath has become academic, for even if it be assumed that the majority holding that the word law in Article 13.2 covered constitutional amendments was not correct, the result on the questions, wider than those raised in Golak Nath, now raised before the court, would be just the same B7, though the power to amend cannot be narrowly construed and urgental to all the articles. It is not unlimited, so as to include the power to abrogate or change the identity of the Constitution or its basic features. Even if the amendment power includes the power to amend Article 13.2, a question not decided in Golak Nath, the power is not so wide as to include the power to abrogate or take away the fundamental freedoms. While interpreting constitutional provisions, it is necessary to determine their width or reach. In fact, the area of operation of the power, its minimum and maximum dimensions cannot be demarcated or determined without fully examining the rival claims. Unless that is done, the ambit, content, scope, and extent of the amending power cannot be properly and correctly decided. The Constitution being supreme, all the organs and bodies owe their existence to it. None can claim superiority over the other, and each of them has to function within the four corners. Cf. the constitutional provisions. All the functionaries, be they legislators, members of the executive or the judiciary, take oath of allegiance to the Constitution and derive their authority and jurisdiction from its provisions. The Constitution has entrusted to the judicature in this country the task of construing the provisions of the Constitution and of safeguarding the fundamental rights. It is a written and controlled Constitution. It can be amended only to the extent of and in accordance with the provisions contained therein. the principal provision being Article 368.20, 221. With regard to the position of the judiciary, the British model has been adopted inasmuch as the appointment of judges both of the Supreme Court and of the High Court is kept free from political controversies. Their independence has been assured, but the doctrine of parliamentary sovereignty as it obtains in England does not prevail here except to the extent provided to the Constitution. The entire scheme of the Constitution is such that it ensures the sovereignty and integrity of the country as a republic and the democratic way of life by parliamentary institutions based on free and fair elections. 14 Super P. For Court Reports 1973 sub CJI. The word amendment has been used in the Constitution in various articles, sometimes in AENA,